Right now, in April 2026, there are 4 specific groups of immigrants who have a window open, a real, legal, documented window to move forward with their immigration status. Not next year, not when the political climate changes, right now. And the tragedy is that most of the people in these 4 groups have no idea this window exists. They are waiting. They are hesitating. They are listening to rumors from friends and family members who are just as confused as they are. Meanwhile, the dates are moving, the bulletins are updating, and every single month that passes without action is a month that could have changed everything. If you are a green card holder, if you have a family member waiting abroad, if you are stuck in a backlog that feels endless, stay with me, because one of these 4 groups might be exactly where you are standing right now. Welcome back, everyone. You are watching Global Entry News, the channel that gives you clear, accurate, and up-to-date immigration information so you can make informed decisions about your future and the future of your family. No confusion, no panic, no misinformation, just the facts you need, explained in plain language. If you are new here, please subscribe right now by clicking the button below and turn on the bell notification so you never miss an immigration update that could directly affect your case. And to everyone who has been part of this community for a while, thank you. Your trust keeps this channel going, and your questions shape every video we make. Today, we are breaking down the April 2026 immigration update and focusing specifically on 4 groups of immigrants who have current priority dates or newly opened pathways that make right now an important moment to take action. Whether you are a green card holder looking to petition for a family member, someone waiting in a visa backlog, or a person whose category just became current in the latest visa bulletin, this video is for you. Let us get into it. Before we get into the 4 groups, let us quickly set the stage so everything makes sense in context. Every month, the United States Department of State releases what is called the Visa Bulletin. This bulletin is essentially the master document that controls who can move forward with their immigration case and who has to keep waiting. It does this through a system of priority dates, the date your original petition was filed, and it tells you whether your priority date is current, meaning you can proceed, or whether it is still backlogged, meaning you have to wait. The April 2026 Visa Bulletin has brought some notable movements, and combined with recent policy guidance from U.S. Citizenship and Immigration Services, there are 4 distinct groups of people for whom this month represents a genuine opportunity. Understanding which group you fall into and what action is available to you is exactly what we are covering today. The first group is immediate relatives of U.S. citizens who have been delaying their paperwork. This is the most straightforward category in the entire U.S. immigration system, and yet it is the one where the most time is lost due to simple procrastination or confusion. Immediate relatives of U.S. citizens, which includes spouses, unmarried children under 21, and parents of U.S. citizens who are at least 21 years old, are not subject to annual numerical limits. There is no cap on how many visas can be issued in this category each year. There is no backlog. There is no waiting list. If you are a U.S. citizen and your spouse, child under 21, or parent is outside the United States, and you have not yet filed a petition, you are leaving the door open when it could already be closed and locked behind your family member, meaning closed in their favor. The reason this group is particularly relevant in April 2026 is the current processing environment. USCIS has made specific announcements about streamlining certain aspects of consular processing and updating fee structures that went into effect earlier this year. Green card holders who became U.S. citizens recently, and there were significant naturalization numbers in late 2025 and early 2026, now have the ability to petition for family members under this unlimited immediate relative category instead of the more restricted family preference categories. If you naturalized recently and have not yet updated your pending petitions or filed new ones reflecting your new citizen status, April 2026 is the moment to act. The difference between petitioning as a permanent resident versus a U.S. citizen can mean years, sometimes a decade or more, of difference in waiting time for your family member. The second group is green card holders whose family members fall under the F2A category and whose priority dates are now current. The F2A category covers spouses and unmarried children under 21 of lawful permanent residents, green card holders. Historically, this category has experienced backlogs that stretched months and sometimes over a year. The April 2026 Visa Bulletin has shown movement in this category that makes it current or close to current for many applicants depending on their country of birth. What current means in practical terms is that if your priority date, the date USCIS received your original I-130 petition, is earlier than the date listed in the bulletin for your category and country, you can now move forward to the next stage of your case. For those whose cases are being processed through a U.S. consulate abroad, this means the National Visa Center can now move your case forward and schedule your immigrant visa interview. For those who are already in the United States in a valid status, this may open the door to filing for adjustment of status, meaning applying for your green card without leaving the country. This is a significant development because the F2A category had seen retrogression, meaning it moved backward, in previous months, and any forward movement represents a real window that you want to capture before conditions potentially change again. If you are a green card holder and you filed an I-130 for your spouse or young child more than a year ago, pull out your receipt notice, find your priority date, and compare it against the April 2026 Visa Bulletin. If your date is current, this is your signal to move forward without delay. Contact your immigration attorney or accredited representative immediately, or if you are navigating this on your own, visit the USCIS and National Visa Center websites to understand the exact next steps for your specific situation. The third group is employment-based immigrants in the EB3 category, particularly those born in countries outside of India and China, where significant backlog relief has occurred. The employment-based third preference category, EB3, covers skilled workers, professionals, and other workers. For applicants born in most countries of the world, excluding India and China, which have their own severe backlogs due to high demand, the EB3 category has seen meaningful forward movement in recent visa bulletins. The April 2026 bulletin continues this trend, and for many nationalities, the priority dates in EB3 are either current or within reach of being current within the next few months. Why does this matter for an immigration channel focused on green card holders? Because many green card holders are themselves in this category waiting to complete the final steps of their cases, and many others have family members or colleagues who are in employment-based processes and need to understand where things stand. Additionally, some individuals who originally entered on employment-based visas and received their green cards are now in a position to help sponsors or understand pathways for people in their networks. For those whose EB3 priority dates are now current or close to current, the critical action is to work closely with your employer's immigration counsel, or your own if you have retained one, to ensure that all required documents are updated, medical examinations are current, and the I-485 adjustment of status application or immigrant visa application is ready to be filed or has already been filed. Medical exam results, for instance, are only valid for a limited period, and if yours have expired while you were waiting for your date to become current, you will need to get a new exam before your case can be approved. One important nuance to understand about the EB3 category in April 2026 is the distinction between the final action date chart and the dates for filing chart in the Visa Bulletin. USCIS announces each month which chart to use for filing adjustment of status applications. If USCIS has authorized use of the dates for filing chart, which is often more advanced than the final action dates, you may be able to file your I-485 even before your final action date is current. Filing early has real benefits. It locks in your priority date, allows you to apply for work authorization and travel permission while you wait, and gets your case into the queue. Confirm which chart USCIS has authorized for April 2026 and act accordingly. The fourth group is diversity visa lottery winners and their derivatives from the DV 2026 program who need to complete their process before the September 30th, 2026 deadline. Every year, the United States makes up to 55,000 immigrant visas available through the diversity visa lottery to applicants from countries with historically low rates of immigration to the United States. The DV 2026 program announced its winners earlier this year, and those winners, along with their eligible spouses and unmarried children under 21 known as derivatives, are in a time-sensitive situation that makes April 2026 a particularly urgent month. Here is why. All diversity visas for the DV 2026 fiscal year must be issued and all cases must be completed by September 30th, 2026. This is a hard statutory deadline. It does not move. It does not extend. If you are a DV 2026 winner and you have not yet completed your visa interview, or if you are inside the United States, filed your adjustment of status application, you are working against a clock that stops at the end of September. Every month between now and then is not just a calendar month. It is a portion of your remaining window. Additionally, the Department of State typically exhausts diversity visa numbers before the September deadline in many regions, particularly in Africa and Europe where demand is high. This means the practical deadline for scheduling and completing your interview may be earlier than September 30. If you are in a high-demand region, do not wait until August or September to take action. The appointments fill up, the cases queue up, and the visas run out before the fiscal year ends. For DV 2026 winners who are currently in the United States in a valid immigration status, the option to file for adjustment of status is available and is often preferable to consular processing because it keeps you in the country throughout the process and eliminates the risk associated with traveling abroad and completing a consular interview. However, adjustment of status processing times need to be factored into your timeline when the September 30th deadline is considered. Consult with an immigration attorney now in April 2026, not in July or August when it may be too late. For derivative family members of DV winners, make sure all documentation is gathered and up to date. Birth certificates, marriage certificates, police clearances, medical examinations, all of these take time to obtain, especially if you or your family members are abroad. Starting this process now gives you the best chance of completing everything before the window closes permanently. Now, across all four of these groups, there are some universal principles that apply and that we want to emphasize because they can make or break any immigration case. Documentation is everything. Every single claim you make in an immigration application must be supported by evidence. Marriages, births, employment, financial support, physical presence, all of it needs documentation. Gathering these documents early, having them translated where required, and organizing them properly is not optional. It is the foundation of a successful case. Deadlines are absolute. Unlike many bureaucratic processes where a late submission can be explained and forgiven, immigration deadlines are frequently hard cutoffs. Missing a response deadline from USCIS, failing to attend a scheduled interview, or missing the September 30th diversity visa cutoff can result in the denial or abandonment of your case with no remedy available. Treat every deadline as the most important date on your calendar. Professional guidance matters. While it is absolutely possible to navigate certain immigration processes without an attorney, the complexity of immigration law and the consequences of errors make professional guidance enormously valuable. If cost is a concern, look for accredited representatives through recognized organizations, nonprofit immigration legal services, or law school immigration clinics. The investment is almost always worth it compared to the cost of a denied case or a delayed green card. And finally, stay informed. Immigration policy in the United States can change quickly. Executive actions, regulatory updates, court decisions, and shifts in processing priorities can all affect your case in ways that may not make national news, but are absolutely critical to your personal situation. Channels like Global Entry News exist precisely to help you stay on top of these developments, so you are never caught off guard. So here is where we land today. April 2026 is an active month for immigration. Immediate relatives of newly naturalized citizens have an unlimited pathway available right now. Green card holders with F2A petitions for spouses and young children should check their priority dates immediately. EB3 applicants from most countries outside India and China have forward movement to take advantage of. And DV 2026 lottery winners are in a race against a September 30th deadline that will not wait. 4 groups, 4 open windows, and every single one of them requires action. Not waiting, not wondering, not assuming, action. If this video gave you clarity today, please give it a thumbs up because it helps more people in these exact situations find this information when they need it most. Share this video with someone in your family or community who falls into one of these 4 groups. It could be the most important thing you do for them this month. And if you are not yet subscribed to Global Entry News, subscribe right now and turn on the bell so every immigration update reaches you the moment we publish it. Drop a comment below and tell us which of these 4 groups applies to your situation. We read every comment, we respond to as many as we can, and your questions directly influence the content of our next videos. We will see you in the next one. Until then, stay informed, take action, and remember, in immigration, knowledge is not just power. Knowledge is time, and time is the one thing you cannot afford to waste. This is Global Entry News.